Hi, this is Josh Blackman. Welcome to the 2025 Harlan Institute Virtual Supreme Court Competition. This is the round of 10. We have match number 4 in this tournament. Representing petitioners will be Emmy Maida and Shayla Bergen from the Baldwin School in Pennsylvania. And representing the respondents will be Audrey Hauk and Karen Bradshaw from Lake Oswego High School in Oregon. Petitioner, begin whenever you're ready.
Thank you. Mr. Chief Justice, and may it please the court. My name is Shayla Bergen, and with my partner, Emmy Maeda, we will be representing the petitioners in today's case. Today's case presents the issue of Texas Law HB 1181, a statute that requires websites containing 1/3 or more of sexual content harmful to minors to verify the ages of all users, including adults. The question presented is whether this court should apply strict scrutiny or rational basis. Justice Kennedy stated in Ashcroft versus ACLU that content-based prohibitions have the constant potential to be a repressive force in the lives and thoughts of a free people. The respondents threatened to do just that by restricting adults' access to constitutionally protected speech under the guise of protecting children. This court should reverse the Fifth Circuit decision for 3 main reasons. First, HB 1181 is a content-based restriction subject to strict scrutiny. This court affirmed in precedents Reno versus ACLU, Ashcroft versus ACLU, United States versus Playboy, and others that content-based restrictions require strict scrutiny, a standard HB 1181 does not meet, as the law is not narrowly tailored and fails to consider less restrictive alternatives like content filtering systems in order to accomplish the government's interest.
And in doing so, the Fifth Circuit decision departs from precedent and overextends Ginsburg v. New York's purview. And second, the law is also both under and over inclusive. Social media platforms and search engines host harmful sexual content that would not be regulated under this law because it does not fulfill the 1/3 threshold. It is also over-inclusive in that just 1/3 of sexual content on a website can warrant restricting 2/3 of protected speech. And finally, the law unconstitutionally compels stigmatizing and unscientific speech that will deter adults from accessing protected speech. These disclosure requirements are both unjustified and unduly burdensome. We ask this court to apply strict scrutiny, overturn the Fifth Circuit decision, and reinstate the preliminary injunction issued by the district court. We welcome the court's questions.
Okay, thank you, Counselor. Let's start. Can you explain to me, why is this a content-based restriction?
Yes, Your Honor, this is a, by definition, content-based restriction, since it deliberately targets content that is sexually harmful content to minors.
But Counselor, does it restrict the content?
Yes, Your Honor, it does restrict the content in that it is applying a huge and heavy burden towards on the.
Well, no, just be careful though. I realize it restricts who can see it, but does it restrict what they can say? In other words, are they allowed to put up any type of pornography they want?
No, they're not allowed to put up any pornography. The Miller v.
No, I understand, but I understand the middle line. But does the Texas law tell them you cannot put up certain types of pornography?
No.
No, but it prevents people from accessing the pornography that they do choose to publish.
But then what content? And we say content-based restriction. What restriction is being? I'm sorry, what content is being restricted?
The content that is being restricted is any content that could be sexually harmful to minors, and that also raises another question that the Fifth Circuit decision also brought up, that this could include things like Marlon Brando movies that has artistic.
So I know that, but I'm still not seeing. Usually, a content-based restriction, the government says you cannot express this message. Is that what's going on here?
Not exactly, but
okay, good. Yeah, not exactly. Tell me why it's not exactly. Let's start there.
Not exactly. Perhaps it's not exactly because it's only allowing certain people to view this sort of content. However,
okay, that's you're getting to certain people. What do you mean certain people? Who are these people?
So in theory, in practice, this Texas law should only show content to adults. However, that's actually not.
Isn't Counselor? I'm sorry. Isn't this just an age-based restriction? I don't see a content-based restriction here. Can you help me out here?
Yes, Your Honor. So the difference here is that the age verification is so not narrowly tailored and burdensome, that it is causing a restriction.
No, so I get that, but I mean, when you're talking about narrow tailoring, that's applying strict scrutiny. But don't we only apply strict scrutiny if it's a content-based restriction? So isn't really the threshold issue, is this content-based? And if it's not content-based, then we don't apply strict scrutiny.
Mm, it's a content-based restriction in that it's targeting speech. And for example, in standards such as Ashcroft v. ACLU or Reno v. ACLU, precedents that are very, very similar to our case and target sexual content, the court applied strict scrutiny. So we encourage that the court should look at past precedents to decide
But
whether.
isn't the most relevant precedent one I don't think you've mentioned, or maybe mentioned briefly, is Ginsburg. Isn't that the most relevant precedent?
So in Ginsburg, one of the major arguments was pertaining to whether children had the right to access sexual content. And so my co-counsel and I absolutely do not dispute that children probably should not be accessing sexually explicit content. But the difference between Ginsburg and here is that adults' access to constitutionally protected speech is being burdened and is being limited by these age verification methods. So Ginsburg has a very different context than this case does.
But isn't Ginsburg precisely about, can the government have an age verification requirement to access adult material? Isn't that on all fours of what we have here? Isn't that like the same case?
Your Honor, I think what Ginsburg said is that age verification requirements can be permissible if they are, in terms of children, if they are rationally related. However, more recent standards, for example, Ashcroft v. ACLU, did not apply Ginsburg critically. And the difference was that when it comes to statutes that are restricting the speech or adults' access to speech, it's a very different situation. Also, another thing we'd like to bring up that differentiates Ginsburg from this case is, for example, even Ginsburg was more narrowly tailored than HB 1181. For example, in Ginsburg, in brick and mortar stores, the employees were only required to identify these people if they suspected the customer to be an adult.
Isn't that simply just a byproduct of the fact that, if you're walking to a store, you can see roughly how old the person is. I mean, we use alcohol all the time. But on the internet, who's clicking, who's buying the mouse. Isn't age verification like the most narrowly tailored way to achieve the government's interest here?
No, Your Honor. There are other ways that you can achieve the government's interests, such as content filtering systems. Which are
I know you guys like content filtering, but that depends on the parent, depends on the kids not hacking it. What if the state decides that the only way, the least restrictive way of accomplishing this is by imposing age verification? Nothing else will suffice. Isn't that judgment entitled to some deference?
Even if hypothetically the government decides that the only way is through age verification systems, there are still ways that the government could narrowly tailor age verification systems and also ensure that privacy concerns are being addressed.
Right, but I know you say there are alternatives, but I'll give you a hypothetical. This is not the facts here. What if the government tells us that they've looked at other states have tried content filtering, and kids get past it right quick? And the only way to stop this is what happened in Texas. And in fact, Pornhub shut down in Texas is actually saving children's brains from being corrupted. How do we second guess it? How do we challenge that?
Your Honor, I believe that there are still parts of HB 1181 that deem age verification not applicable here and also burdensome on adults for other reasons. For example, there were no guarantees in HB 1181 about what the data behind age verification, where is that going, and how's that being stored? And so improvements into sections like these in HB 1181 would be necessary in order to deem age verification acceptable.
All right, you may proceed, Counselor.
Thank you. Now, let's discuss some less restrictive alternatives that that precedents from the Supreme Court have said are required to be addressed before when applying strict scrutiny. So first, there are content filtering systems. Yeah, I know we like them. So content filtering systems can be implemented on Wi-Fi, as they have been in schools and libraries and have been and have been effective. And there are also device-based content filtering systems that actually do more than what HP 1181 is saying.
Who has to install those? Is that something that parent has to install?
That would be something that the companies, the technological companies themselves would have to install on a device.
So do you see a problem with making the tech companies? Isn't there First Amendment issue there that now you're forcing devices to be installed? Isn't there another legal issue present?
Perhaps, well, I think that there wouldn't be, because first of all, there would be no privacy, much less privacy concerns when it comes to adults inputting their information to, oh, time's up, but
Okay,
adults inputting their information to, say, companies rather than these shady.
Thank you, Counselor. Thank you. Okay, respondent, do you have your time? Whenever you're ready to proceed.
Hello, my name is Karin Bradshaw, and this is my friend Audrey Hawk. And we would first like to refute the point that this is a content-based restriction. We would like to say that no content is being limited. Any form of legal pornography can be posted on the internet, and there is no restriction as to that actually making its way onto the internet. The only restriction is who can access it, which makes it an age-based verification and not a content-based restriction, which means that strict scrutiny does not apply. I believe that it's unrealistic to assume that content will be watered down to reach the 1/3 standard. Any idea that a company such as Pornhub would have 2/3 of their content not sexual content that's deemed inappropriate for children is just something that I don't believe is going to happen. Do you have something to say?
Yeah. We would also like to point out that our friends on the other side mentioned the case Reno versus ACLU. And we would like to point out that in that case, it was stated that the internet is a medium for adult users to access information. So this case is specifically focused on monitoring children's access. It is not at all hindering adults' access because that is still legally protected in this case.
And we would like to state that there is not a substantial difference between the Ginsburg case and the case that is being applied here. The only difference is the medium of the internet. And as was said before, verifying someone's age is done in brick and mortar stores. It can just be done visually, and the medium of the internet sometimes does not allow for that to be done visually, so it must be done in other means. Websites such as gambling websites already require age verification, and that is not seen as an undue burden on people's privacy, their private information that's already used. And so if that is not restrictive, I believe that the same standard should be applied here for pornographic content.
Well, let me ask you the same question I asked your friends, but in reverse. What is the trigger for the Texas bill? What types of websites does it apply to?
It applies to websites that contain 2/3 obscene content for children. So something that does not have any sort of artistic, societal value.
Right. So if there's no pornographic material, the law doesn't apply.
No.
If there's 10% pornographic material, the law doesn't apply. If there's 2/3 pornographic material, the law does apply. Am I understanding this correctly?
Yes.
Isn't that a restriction imposed based on the content? Isn't that like necessarily what a content restriction is?
The restriction is being applied based on the content, but the content itself is not being restricted. It would be content.
Hold on. Okay, so it's a restriction based on the content, but it's not restricting the content. Is that right?
All pornographic content is still allowed to be posted on any of these sites. It's just attempting to restrict who has access to view the content.
But wait a minute. Can you give me what's your best case to describe this distinction between a restriction based on content, but the restriction does not restrict content? What's the best case you have?
Well, in Ginsburg, the content of the actual pornographic magazines themselves was not restricted. For example, putting a cover, like a sheet of paper over the top of a magazine, but still advertising the magazine as available to adults to consume, does not restrict the company from doing the photo shoots, printing the magazine, distributing it to stores. It just restricts viewing that content until the person has been age verified.
Okay.
Counselor,
Go ahead, Justice.
If I could ask a question, I mean, you point to Ginsburg, but for the question of, what do we do when content's obscene for children but not for adults, we have at least 5 precedents addressing that question, saying that we should apply strict scrutiny. So why shouldn't we apply those?
I think that in this case, Ginsburg is the most similar to the situation that the Texas House bill is directly attacking. I think that in the case of Ginsburg, it is specifically designed to protect minors, and in some of those other precedents, it is more just considering pornographic material, not necessarily as focused on the protection of minors as Ginsburg is.
I would also like to point to the Playboy case. That was a case where content was restricted not only for children, but also for adults by only showing pornographic content at certain time windows of the day when they believed that children would be asleep, which meant that adults wanting to access pornographic content could not access it in certain points of the day, even though they were allowed to access that content. So that was evaluated with strict scrutiny because it was placing a truly undue burden on adults accessing the content, whereas in this case, all adults can.
But that seems to have more to do with whether or not the law was the tailoring, not what type of scrutiny should be applied. So is that, how do you reconcile that? I mean, that placed more of a burden, but we don't look at the burden and then how much of a burden it places on parents and then decide what level of scrutiny to put on parents. We look at, or sorry, on adults, we look at what the law is doing, then decide the scrutiny, then decide whether or not the burden is too burdensome.
Can you repeat the question?
How do you, I think what you just said, how do you make sense of that? Because you were explaining that the law, the burden was too much in Playboy, and so then they applied strict scrutiny, but that's not how it works, right? We decide what level of scrutiny to apply before we assess whether or not the burden's too much. Is that incorrect?
No, that's correct. I think as well as in this case, they did apply rational basis scrutiny, and then it was considered by one of the parties that they didn't agree with the choice. So that is why this case is back in front of the courts, because they are trying to reevaluate it. So I think that in each of those cases, it was applied in a certain way, and then it was deemed unfit by a party, which made it go back to the courts, which then in the case of Playboy, it was then reversed. But in this case, we are still attempting to keep it as it is.
Okay,
You may proceed.
Our friends on the other side mentioned at one point in their argument that content filtering systems would be able to restrict pornographic content from students accessing it on specific Wi-Fi systems. We would like to point out that certain content filtering systems, like the ones they are proposing, can, in an overabundance of caution, prohibit anyone on that internet from accessing a number of sites that aren't pornographic. And that can...
Counselor, can you talk for me about the content filtering? Your friend on the other side, they really like content filtering. Can you tell me why that may not be, why that wouldn't pass constitutional scrutiny?
Well, first of all, for overriding content filtering, for example, they discussed Wi-Fi, putting restrictions on the Wi-Fi. If a child simply turns off their Wi-Fi and switches over to using cell service, that bypasses the restriction. And so I believe that that would not be effective. I also believe that requiring companies who produce computers or phones or other products to restrict content for children is placing an undue burden on the companies themselves, as that is not within their means. They are simply creating a product for people to use and putting content.
But your friends say that it will be almost as effective as the age verification. Wouldn't it be less burdensome than what you have now, where you have to upload your private information to the cloud? Isn't there less burdens by having the content filtering installed on the phone?
Well, the question is, how would the content filtering even operate? When you purchase a phone, would you have to submit all of your data, your driver's license, birth certificate, and to verify your age so that the content restrictions are placed on the device itself? Isn't that doing the exact same thing? Also, that places a burden on people who will never view pornography. There are people who never want to view pornography. And if those content-based restrictions, you have to file all of those things when you're getting your phone. So that means even more people are having to submit their information
Wait,
than
hold on. Maybe it's a tech question. When your friends at their side say we need to install content filtering, does that require uploading ID to any site? Maybe I wasn't sure about that.
so obviously you're not filtering content for adults, you're only filtering content for children. If you were filtering content for all people, then that would, of course, restrict the free speech of people viewing
No, but do
pornography.
you have to upload ID? With the content filtering, yeah, I'm just not sure about that point.
What other way would you verify that the device that you're restricting is the device of a child?
I thought it was that the parent who buys a phone decides to install it for their kid's benefit. Isn't that how it works?
Well, then that's a separate issue of parents having the personal discretion as to whether they want their children to be able to view pornography or not. And I don't think that, and we don't believe that a parent should be allowed to make that decision. For example, a parent for another age restricted item, such as cigarettes, cannot decide, I think it's okay for my 12-year-old to smoke a cigarette and hand one to them. This is giving parents the personal directive to be able to say, I'll put the restrictions on my daughter's phone because I don't want her viewing pornography, but I won't put the restrictions on my son's phone because I'm fine with him viewing pornography. It's not the parent's decision to make. And in this instance, it's for the protection of children, and it should be the government making that decision. So allowing the personal decision for parents to put it on would not solve the issue. And so it would need to be from an actual, this is my age, this is the device I have, I need to file to have the content restrictions placed on blanket all children's phones.
Okay.
That was an interesting point you made, counselor, about whether or not you said that's not the decision for the parents to make. But that's another question that, I mean, this law may raise is this law getting in the way of parents' own decision making about whether or not a parent wants to show their child, maybe they want to use it for educational purposes, or that's not something that we need to get into about why they want to use it. But if a parent wants to show their child this information, it appears they can't. Is that getting in the way of any of their rights? Do you see a problem there with this law?
No, Your Honor. I believe that there are several societally beneficial ways to demonstrate sex education to children, and websites that have the societal value of teaching children about sex ed does not fall under this restriction. They would not be restricted. Those websites would be open for parents and children to view. And I do not think that parents should be able to make the decision of showing pornographic content made for the sexual arousal of adults to children to educate them. It can be done in other means. And nudity can be allowed in those situations, just not a content that is made for the sexual arousal of an adult.
May I proceed, Counselor?
Furthermore, this case is about overall, it's about restricting the minor's access to pornographic content. And one of the issues being presented is if adults will be burdened by having to further prove their age. And if they are, in fact, an adult, it would not be a burden to simply just verify their age or show an ID, because they will still be able to access this content. It is only so they would not be really affected as a means, because they are still allowed to access these sites.
It is up to each person's personal decision as to whether or not they would like to show their ID. For example, also with any other age restricted item, it is not a burden on the purchase of alcohols to show an ID when you're purchasing alcohol. If someone says, this is restricting my means to be able to purchase alcohol because I have to show my ID, no, you are exercising your own rights by choosing whether you feel comfortable or you do not feel comfortable showing that information. And as long as that option is open to you, available, and unrestricted once you verify, that is up to each own individual person's decision to make.
Council, do you think there's a percentage at which Texas's law wouldn't make sense anymore? Like, do you think that if Texas said if you have 10% of pornographic material on your website, then you fall under this restriction? At what point would you draw the line for saying that Texas's law is no longer constitutional?
I believe that the 1/3 rule was made very intelligently. I think that there are like restricting an entire website based off of content that is not their main motive to produce, especially when it is not the company's own ideology, but individual creators creating content. If it's a very small minority of, then the entire website should not be branded as a pornographic website when their likely main directive is not to produce pornography.
Okay. All right. Just about time. Thank you so much, Counselor.
Thank you.
All right. 5 minutes rebuttal whenever you're ready.
Thank you. Mr. Chief Justice, and may it please the court. In this rebuttal, we'd like to bring up the disclosure requirements. First, the disclosure requirements by nature are a content-based restriction because it directly involves the government mandating the expression of specific message or viewpoints. And in this case, that pornography is addictive, and etc. And this means that it's not just content-based, but it's also viewpoint-based. And Zotterer outlines a rigid test when it comes to the government compelling speech. And it's that the disclosure requirements must be justified and uncontroversial. However, the Texas proves neither, and therefore this disclosure requirements is, if not one of the most unconstitutional parts of this case, of this statute.
Right. So, Counselor, I want to go back to this issue of the content-based versus rational basis. What do you think about intermediate scrutiny? What if we don't agree with you? What do we think the intermediate scrutiny is a relevant standard? How does this case turn out?
Even if this court applies intermediate scrutiny, the petitioners would still prevail. That's because when it comes to intermediate scrutiny, it's like substantially related to the interest. However, HB 1181 is not substantially related to the interest. For example, first of all, the 1/3 threshold makes it so that it's over-inclusive, and it's not actually regulating the sexual content that many minors are coming across. Many minors are coming across pornography through search engines or social media. But
Counselor, I want to just pause here. I get with strict scrutiny, it's very hard for the government to win. But with intermediate scrutiny, it's a little bit easier. And I think the state, do you agree with me? The state has a very important interest in keeping kids away from this material. Do you agree with that?
yes.
And isn't asking for ID something that government does all the time when you want to buy a magazine or you want to buy alcohol, buy tobacco? I mean, isn't this just the sort of thing we've done before, just online? Isn't this in the same ballpark as what we've seen in the past?
Your Honor, first of all, you are not constitutionally entitled to your right to gamble.
What?
And additionally, it's a very different situation when you're submitting identification online rather than in brick and mortar stores where you would gamble or purchase other goods.
Yes, Your Honor. In brick and mortar stores, the privacy concerns are far different than what we see online. And we also—
Counselor, I get that. I think you're answering sort of a different question, though. My question is a little more simple. With intermediate scrutiny, the government doesn't have a perfect answer. Sometimes good enough is good enough for the government with intermediate scrutiny. Why isn't having, the age verification, right? It does have some effects, does chill some speech. Why isn't that good enough for intermediate scrutiny?
this law isn't good enough to satisfy intermediate scrutiny because it is not substantially related to the interest. And there are some major faults with the statute that prevent it from being so. And one of them is the 1/3 threshold that I brought up earlier, but also another is that they have not made the effort to try to make it substantially related. For example, these age verification requirements are very thorough and are also, completely allowing the websites to handle the adults, federally important federal identification. And those are things that show that the law is not even tailored enough to satisfy intermediate scrutiny.
Okay, may proceed.
Thank you.
So additionally, one of the things that we wanted to talk about that our friends on the other side mentioned was, content filtering and having to install a content filter. First of all, you do not have to submit your ID to install a content filter on your device. When you purchase a device, you can install a content filter by confirming your age. And you put this content filter on when you buy the device. And so this would make it a lot less burdensome on adults and allow adults to monitor what their children are viewing online without preventing all adults and burdening adults and chilling adults from accessing constitutionally protected content online. And we've seen companies actually already have very similar content filters to the ones that we're mentioning. So for example, Apple's screen time is something that you can put on as soon as you purchase the device. And it can be put on by the person who purchased the device, and it can prevent children from accessing questionable content online. So that's something that's already been effective and has already exists.
And furthermore, another point we'd like to bring up is the burden that it causes on adults, because our friends on the other side said this burden wasn't that much. However, a few reasons. Thank you.
Okay, thank you so much. Okay, the case is submitted. Well, okay, that was very good. That was very good. That was harder, wasn't it, than the prior round? The reason why I do this again, it's not because I'm a mean person. Maybe I think I am right now. But the reason why we do this is sort of test you and see how you think on your feet. Especially when you pressure. It's very hard to do this when I'm interrupting you every 5 seconds and I don't let you get your answer out. And just when you start getting one answer out, you come in and I interrupt you with something else. So it's actually very, very tricky to do this. I think that this round was pretty good. I'm going to give some feedback. It's constructive. This is for both teams equally. I think both teams did some of the same things. At times it felt a little bit informal. You can enjoy yourself when you're arguing, but it seemed like you were like kind of joking around a bit, like, oh, we like content filtering. Like, it's almost like a little bit humorous. I would be very hesitant to sort of laugh or make any sort of attempts at humor. In fact, if you read the Supreme Court manual, they give a guide for the advocates. They say humor is disfavored. Now, there's some advocates are really funny, but they can get away with it because they've been doing this for 20 years, right? You're not at that level yet. So I would be very hesitant about seeming informal. Every question is answered yes, Your Honor, no, Your Honor. I heard a lot of well, and we would like to say, and I believe. You got to delete that from your vocabulary. It's yes, Your Honor, no, Your Honor. Those are sort of like locutions or things that people say to sort of fill space. It doesn't actually add anything. So I would make every single word count. When you start, Mr. Chief Justice, may it please the court. You don't need to introduce yourselves. I know your names. I just said your names, in fact. We don't need to know your names. It's not necessary. The handoff in a couple is a little bit awkward. Kind of looked at you going, are you going? Whispering, it's your turn. I would just adopt a hard rule of alternating 1-1. That way you know who's up next, and it shouldn't be sort of a guess of who's going to speak next. So it's just a couple times a little bit awkward. Keep your hands down. I shouldn't see your hands. Not like this, and not like this, and not like well. Keep your hands at the table. When you use your hands, it can be a little bit distracting when we gesticulate. Try not to read. I saw a couple times maybe you're reading from a screen. Looked like maybe you're using a mouse with your hand or you're swiping on a tablet. I would avoid that. It's not good when you're reading. You're not connecting with the court, and it looks a little artificial. I'm guilty of this, but there are a lot of ums. There are a lot of ums. If you go back and you watch this video, you'll hear all the ums, and it's something that we all do. We have to be mindful of it and try to reduce how often we do the ums. We're all guilty of it. I do it all the time. I'm giving you advice that I myself don't follow. On the substance, I think you understand it pretty well. You cite all the relevant cases. You know the difference between strict, intermediate, and rational basis scrutiny. You know why one case applied versus the other. You argument over-inclusive and under-inclusive, which is good. You talk about other means such as the content filtering. I think your substance was good. What sort of, and I mean this in a positive way, what sort of separates the teams that go into the next round is what I call the polish. It's like how clean is it? And the polish could just be a little bit tighter here. Also, just for my friends from Oregon, courtroom attire, please. Yes, to dress for the court. I don't know if you had some other thing going on today, but yeah.
We're here.
It's the middle of the school day right now.
Well, you
Sorry,
can wear a suit to school.
Yeah, there's not many places to put it, but we'll keep that in mind for the next time. Sorry about that.
That's all right. Yeah, I mean, just it's something to just keep in mind. I wear a suit to school every day, but maybe I'm a weirdo. I That's really all the feedback I had. Addie, anything that you wanted to add?
Both of y'all did very good. I think y'all definitely had a grip on the substance because it didn't always take y'all a long time to respond. Y'all were actually pretty good. Conversational is always good, but I agree with Professor Blackman that there were some times where it got a little too informal. But the conversational nature is a good skill that not everyone has. So you should definitely work with that. And I mean, that part is good. Another thing that I noticed was when judges ask you questions, sometimes you have to bring the judge back and remind, like, instead of going down some tangent, you can always end the question maybe or say something and remember the question presented is this, and steer the judge where you want to go so that way you're in a good spot. Yes, follow the judge with the questions that they're asking, but don't let the judge get you into a rabbit hole. Remind them of the big picture, is in my opinion. That way you get your case across. Because sometimes a judge will kind of try to confuse you and to see if you can stay in your lane and not lose track of your argument, which is very hard to do. And yeah, the hands is another thing. I do the same thing. I'm also saying I'm a lot right now, so take everything I say with a grain of salt. Um, the hands, it's hard to do, but you do keep them down during the argument because we notice it. And that's all I have to add.
You really just keep it on the lectern and don't lift it up, and then just forget they're there. You people twiddling pens, and they pull. I had one pulling their hair, and you kind of go like this, and like this, down, 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 down. The judges do whatever the hell they want, right? The judges, their hands are up in the air, they're going crazy. Scalia would always go, yeah. Scalia with all these hand signals, but you're not the judge. Unfortunately, there are different rules. It's an unfair double standard. That's all I have. Any questions you want to ask for us?
We're okay. Thank you. Thank you for
Thank
the
you.
advice.
Was that fun? Was it enjoyable?
Yes.
Yeah, it was good.
Okay, my friends in Oregon, was that enjoyable?
Yes, it was.
Good. I'm glad you enjoyed it. Well, thank you so much. I think it's gonna be hard deciding which teams advance next round. The teams are so competitive, but I'm really grateful for your time and have a lovely day.
Thank you. Thank you.